Hi, my name is Rachel Yakubowicz, and thank you for joining me for my debrief of the Endrew F. First Douglas County School District case. The facts surrounding the Endrew F. case. This was a United States Supreme Court case that held that the Individuals with Disabilities Education Act, or the IDEA, required schools to provide students an education that is, in quotes, reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Chief Justice John G. Roberts was the decision maker and overseer of this court case. Endrew is a child with autism that attended public school from kindergarten through 4th grade, where in April of 2010, Endrew's parents rejected his 5th grade individualized education program, or his IEP, proposed by the Douglas County School District. Endrew's parents believed that the proposed IEP was very similar to the previous year's IEP, under which their child's academic and functional progress had stalled greatly. Endrew's parents then withdrew him from the public school and placed him in a private school that specialized in the education of children with autism. There, Endrew's behavior in the private school setting improved significantly. His academic goals were strengthened, and he thrived. The case itself arose because Endrew's parents were unable to obtain tuition reimbursement for the cost of the use of the private school placement. Endrew's parents then sought reimbursement for the private school tuition payments at a due process hearing, and therefore sought judicial review of the hearing decision in the U.S. District Court for the District of Colorado after the hearing officer did not grant the first relief that they were seeking. The District Court then appealed to the U.S. Court of Appeals for the 10th Circuit, and in these proceedings, Endrew's parents argued that the IEP proposed by the public school was mostly unchanged from his previous IEPs, under which he made minimal progress. The 10th Circuit rejected the parents' arguments and concluded that Endrew had received a free, appropriate public education through the district's IEP because they were calculated to provide any educational benefit, despite its intellectual impact or progress for Endrew. Finally, Endrew's parents then appealed the case to the U.S. Supreme Court, and the court overturned the 10th Circuit's decision. The crucial issue that was addressed in the Endrew F. case was Endrew F. clarified the substantive standards for determining whether a child's IEP, the centerpiece of each child's entitlement to a free, appropriate public education under the IDEA, is sufficient to confer educational benefit on a child with a disability. The Supreme Court's final decision in the Endrew F. case was the court held that to meet its substantive obligation under the IDEA, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. In clarifying the standard, the court rejected the merely more than de minimis standard applied by the 10th Circuit. In determining the scope of FAPE, or Free Appropriate Public Education, the court reinforced the requirement that, in quotes, every child should have the chance to meet challenging objectives. How should the IEP teams implement the Endrew F. standard for children with the most significant cognitive disabilities? The department recognizes that there is a small number of children, those with the most significant cognitive disabilities, whose performance can be measured against alternate academic achievement standards. Alternate academic achievement standards also must be aligned with the state's grade level content standards. Therefore, an annual IEP goals for the children with the most significant cognitive disabilities should be appropriately ambitious and based on the state's content standards, and again, in quotes, reasonably calculated to enable the child to make progress appropriate in light of that child's circumstances. Now, how did the Endrew F. case clarify the standard for determining FAPE and educational benefit? With the decision in Endrew F., the court clarified that for all students, including those performing at grade level and those unable to perform at grade level, a school must offer an IEP that is, in quotes, reasonably calculated to enable a child to make that progress appropriate in light of the child's circumstances. This standard is different, though, from and more demanding than, in quotes, the merely more de minimis test that was previously, as I mentioned, applied by the 10th Circuit. As the court stated, in quotes again, the goals may differ, but every child should have the chance to meet challenging objectives. And this is despite whether they are special education or regular education. What SEAs now do differently as a result of the Endrew F. decision. SEAs should review policies, procedures, and practices to provide support and appropriate guidance to school districts, and IEP teams should ensure that IEP goals are appropriately ambitious and that all children have the opportunity to meet these challenging objectives. States can help ensure that every child with a disability has an IEP that enables the child to be involved in and make progress in the general education curriculum, and is also appropriately ambitious in the light of the child's circumstances. While many states and school districts are already meeting the standard established in the Endrew F. case, special education teams need to work together to ensure that they are holding all children with disabilities to high standards and providing access to challenging academic content and achievement standards as well. What IEP teams should do differently now as a result of the Endrew F. decision? The court in Endrew F. held that to meet its substantive obligation under the IDEA, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances, and then rejected the merely more than de minimis or trivial progress standard that was stated prior. And although the court did not determine any one of these tests for determining what appropriate progress would look like for every child, IEP teams must implement policies, procedures, and practices relating to identifying present levels of academic achievement and functional performance, the setting of measurable annual goals, including academic and functional goals, and how a child's progress toward meeting annual goals will be measured and reported, so that the Endrew F. standard is met for each child with a disability. Separately, IEP teams and other school personnel should be able to demonstrate that, consistent with the provisions in the child's IEP, they are providing special education and related services and supplementary aids and services, making program modifications, providing supports for school personnel, and allowing for appropriate accommodations that are reasonably calculated in light of the child's circumstances, and enables the child to have and to meet the challenging objectives mentioned prior. How the Endrew F. decision impacted placement decisions. Consistent with the decision in the Endrew F. case, the department continues to recognize that it is essential to make individualized determinations about what constitutes an appropriate instruction and services for each child with a disability, and the placement in which that instruction and those services can be applied or provided to that child. Therefore, we note that the placement in irregular classes may not be the least restrictive environment or placement for every child with disability. The IDEA Part B regulations specify that each public agency must ensure that a continuum of alternate placements, including instruction in regular classes, special education classes, special schools, home instruction, placement in private schools, and instruction in hospitals and institutions, is available to meet the needs of children with disabilities for special education and related services. It has been proven many times in the process of education that there is no one-size-fits-all approach to educating children with disabilities. Therefore, decisions for these students must be individualized and made consistent with a child's IEP. Without doing so, we are not providing our students with the best possible education to benefit their needs, goals, and abilities. Thankfully, court cases such as these have shaped education as we know it and have informed so many individuals on how we can provide a better educational practices and experience to our students. It's what they deserve, therefore it is our job to make sure that these students are provided more than an adequate education that benefits them both personally and educationally. Thank you so much.